that the professional bodies did not find any transgression from her part in relation to what is being alleged in the application. The UDM chair speaks about her being embroiled in many litigations, and she is disputing that she's embroiled in any form of litigation. She goes further and explains her involvement in terms of her being instructed by the Department of Environment, Forestry and Fisheries, which I think in that part she is executing her role as an advocate of the High Court, not as a suspect or a respondent or any other form. Now, Chair, from what I've read, from all angles, from the GG attorneys, from the UDM, the response from Advocate Power, I am of the view that this committee can continue to be derailed to do its work by allegations, by accusations, where there is no concrete and substantive submissions to it. Was the problem, Chair, is that if we continue like this, of course we must be transparent, of course we must be open, of course we must allow even communities to play their own role, as this is a matter of public interest. But I think we must at some point be patient with the process and not bring some frivolous applications that are meant to delay this inquiry. I'm saying this, Chair, because in the detailed response from the evidence leader, she goes to an extent of detailing how Mr. Xulu is a character is a Stalin grade character. There are things that are, I won't repeat, Chair. I mean, I won't repeat issues of attachments of properties and other things. But there is that character that is revealed of the applicant. So there are a lot of things that are being revealed to the committee, Chair, but I don't think some of the detail will further go will further go deep into them. So I move, Chair, that the recusal application be not accepted, and the committee proceed with its work, and this be communicated with the applicants in due course. Thank you very much, Chair. Oh, Chair, sorry, one issue, just one issue. I don't think, Chair, it will be adequate for the committee to call any other person outside this committee or this inquiry to come and do an oral presentation. Mr. Xulu, Mr. Mkhwebane, Mr. Mkhwebane, and all those people are not part of this inquiry, and therefore we want. I don't think it would be adequate for us to call them to do any presentation in this committee. We have received the affidavits and the application. Thank you very much, Chair.
Thank you, Honorable Ngola. Honorable Mimi Gondwe.
Thank you very much, Chairperson. Let me also start by appreciating the effort that Advocate Bauer has made in terms of taking us through her response to the recusal application. I also share the sentiments of Honorable Ngola that there is really no need to call anyone outside of this committee and who will add relevance, who will not add relevance to the work of this committee to come and speak on this matter. Chairperson, I think it's also important for me to state from the outset that I support Advocate Bauer's decision to decline this invitation to recuse herself as evidence leader, in this inquiry. Chair, the matter that is being used as a basis of a foundation for her recusal application is so far removed from the work of this inquiry, which inquiry has only just recently started with its work. Advocate Bauer has just confirmed to this committee that she's been on brief in relation to, the matter raised in the recusal application since 2019, and there are several pending applications in terms of this brief. As such, I want to repeat that the matter concerned not only predates the work of this committee, but is also very complex in nature and has no bearing or relevance to the work of this committee. That have been said, Chairperson, to date, in my opinion, Advocate Bauer has not so much as uttered or done anything that would warrant or necessitate her recusal from this inquiry. If anything, she's conducted herself with the professionalism and the decorum that is expected of someone of her standing as senior counsel of the Cape Bar and a senior officer of the court. I also agree with her assertions in the response to her recusal application, namely that she's not the ultimate decision maker in this inquiry, and neither is she a member of this committee. Her role is merely limited to that being of evidence leader, an evidence leader that, I might add, Chairperson, that leads evidence that can either exonerate or implicate the public protector. I would therefore request that we move on. We don't even, so much as after this, give any more thought to this recusal application, and we carry on with the work of the committee. We're just about to listen to the last of the witnesses called by the evidence leaders, and thereafter have the PP lead her witnesses. And we really want to get to the next phase of the work of this committee. Thank you, Chairperson.
Thank you, Honorable Gondwe. Honorable Dlakude.
Thank you very much, Honorable Chairperson. Good morning to you and my colleagues and the evidence leader, Advocate Bauer. Thank you very much, Advocate Bauer, for your detailed response to this recusal application. Honorable Chairperson, I will not waste time of this committee, but I want to agree with my colleagues on what they are saying, that as a committee, we must reject this recusal application because there's no basis for this recusal application. Advocate Bauer gave us a detailed response of which we are satisfied with, so we cannot agree with this recusal application as a committee. We support the response given by Advocate Bauer, and also we are looking forward to continue with the work that is before this committee. So I fully agree. Honorable Ngola also went into details with regard to his response, of which is a correct diagnosis of what transpired here. Thank you very much, Honorable Chair.
Thank you, Honorable Dlakude. Honorable Benedicta van Minen.
Thank you, Mr. Chair. I really want to agree with the vast majority of my colleagues, in particular the Honorable Dr. Gondwe. I also want to point out that the Honorable Holomisa pointed out that we have to have both sides of the story. That's exactly what we have. There is a rescission application, which Advocate Bauer more than adequately answered this morning. We have heard both sides. I think that this committee really has no choice at all except to dismiss the recusal application. It is ill-founded. It does not have any basis in relevance. Some of the facts certainly appear to be rather dubious and to be stretching. And I think no case has been made at all. I also think that it needs to be pointed out that those of us who have worked in practice in law are very aware of malicious litigants. And unfortunately, it seems to be a discipline which does attract its fair share of people who seek to possibly misuse the process. And I think in this particular case, what we need to do is dismiss this and move forward. We have now spent 3 months dealing with direct evidence. We're now at a situation where we indeed have a last witness to hear, and then we will be dealing with the public protector's side. And I think we need to move forward to do that, not just for this committee and for Parliament, but also for the good of the people of South Africa. Thank you very much.
Thank you, Honorable Van Minen. Honorable Maneli.
Thank you, Chair. Greetings to honorable members and Advocate Bauer, who has presented a response. Firstly, Chair, on my part, it is to just indicate that indeed this is a response from Advocate Bauer, and therefore accept the decision of Advocate Bauer not to recuse herself as evidence leader of the inquiry, as there was no single ground given that proves her bias in the way she has led evidence in this inquiry. As we are now almost one witness left to the on the evidence led on charges brought against the public protector. I think for me that's important. That we're almost at the tail end, and I want to bring this point later about time and space. But the second issue, Chair, is that there's not been any evidence to prove any ethical issue which could be raised to the effect that it would taint the inquiry, just even from a point of morality, which is very difficult to prove. But there's no such a thing that has been raised. So therefore, I second that point, that we accept her decision. I think for me that's very important. It's her decision, and she has given a comprehensive response in that regard, and the committee accepts that. And accepting it, I want to then come back to that point, just to underscore this point about time and space. Because when you listen to the presentation, and also having read the document, we are talking about a matter that predates the functioning of this inquiry. And Advocate Bauer is not elected into this committee. She came through an appointment process as an evidence leader. But this has been made public because our meetings are public. Therefore, from a time and space point of view, if there was any matter that her being brought on board would taint the inquiry, genuinely that matter would have been raised at that point, not when evidence has been led and so on. Of course, it is when you read the report in detail that we are at a point where some of the characters have been pointed not long ago, as pointed in the report, that there's this invoice here that relates to this character, and unfortunately it is this character that is also a beneficiary in another transaction that happened after a court order has been made to freeze the monies that would have been there. So now I think, Chair, if we take then that into account, you can only come to that conclusion that she makes, that in essence, we are not even party to the matters that predate this committee. But it can only be brought to this committee in order to derail the committee from doing its work. And we even have suggestions that we then bring people in another matter, in another court. And then we become some tribunal that now starts looking at that matter which we have no powers to deal with. And therefore want to suggest, Chair, even for the future, that probably theory has not helped us much because we thought everything will be confined to what is the inquiry. But as you know, if theory fails in that regard, events will teach you. The events are beginning to teach us that we can get out of what we are mandated for if we do not also screen better. And I want to make the point on why I say screen better. Immediately, there's a reference to a criminal matter before courts. The first point really would have been, do you have a case number? So that at least we know there are charges brought against a person and these are tried in a criminal court if it's a criminal matter. So I don't want us to then do it differently by then saying it's an issue of giving the other side an opportunity to be listened to try and build up a criminal case we are not even aware of in that regard. Same to say that as a citizen, over and above being a member of parliament, but just as a citizen, and I would want to say this with a great deal of respect, Chair, that my assumption may be correct that even the UDM may have not been aware of the details that are being given to us now, because if they were aware, I would be worried as a citizen of the country that you have a situation where public funds are being recovered. And there's a whole lot of story around that. And then we get involved in a way that we ignore all those things, but try and compromise an inquiry that seeks to talk to accountability by institutions that need to protect a public. So I'm just saying, for me, that's something I would say, as I said, respectfully, it's an assumption I made that these were just wild allegations. They may have not been looked at, but if this detail would have been known, that you may actually get into a web of characters that are seen to be implicated in a number of situations where their extraction of state resources that belong to the people in terms of their taxes is being questioned. So I'll be worried with that. And I hope we do not want to change this to a tribunal to try and look at such matters. And therefore, Chair, as I said, I agree that we shouldn't be going that route. We will be putting ourselves into unnecessary problems. If there's anything, Chair, we should be able to agree that the evidence leader should continue to do the work appointed for. At this point in time, even the terms of reference of her appointment have not been under question in the whole discussion we have been having. And therefore, let's continue and do the work that we are expected to do. And like I said, if I was a taxpayer, I'll still be asking the question, when you open another inquiry on a litigation in a matter with the Department of Forestry and so on, is it the mandate that you've been given by the National Assembly as the committee? Because we are now defocused. So I'm just saying, Chair, for me, that will really be the point. Let's move forward. There's nothing thus far that talks to anything in that regard that stops the inquiry and then take a detour to try and be another tribunal somewhere else. But the suggestion I'm also making, Chair, is that if the letters now, having been taught by events, if the letters can also be screened a bit when you receive them, try to get some background information so that we know if that letter really deserves the attention of this committee or not. Otherwise, tomorrow it's going to be on another member. I agree with that. Then is another one. In fact, by the time you think of it, it will be January next year. And you've done nothing in that regard. And will be raising matters that could have been raised if they were genuine right in the beginning as a way of protecting the process. But quite clearly, that's not the case at this point where we are. I want to submit, Chair, without getting to the other points in detail. Thank you.
Thank you, Honorable Maneli, for your contribution. Honorable Mautwe.
Thank you very much, Chair. Chair, let us state it categorically clear from the onset that we want to continue with the inquiry. However, we don't want to continue with questionable characters amongst us, because this thing, Chair, is very, very crucial. And we must not take it lightly, like I hear my colleagues saying. So, Chair, I have said this before, and I will say it again, at the risk of sounding like a broken record. Chair, this is the first Section 194 inquiry. It is the first of its kind in a post-apartheid South Africa. Let's agree on that one. So therefore, this process is bound to be contested at times with too many interests that will require all of us at all times to be balanced and put aside our petty partisan mandate that are not in the interest of Parliament and definitely not in the interest of the public at large. Chair, if you remember my initial response to the application for your own recusal by the PP, I said that what was presented by the PP legal team needed you to appreciate that such a process will need all of us to have confidence that we did everything in our power to make this process appear as objective as possible. There must not be an instance wherein we are discussing presiding officers and evidence leaders as the focus of the process and how we view the outcome. If we do that, Chair, our people will not have confidence on this process. And I still maintain, Chair, that this is an important objective that we must all seek to maintain and achieve throughout this process. You may think that the reasons advanced are nonsense and opinion, as I heard you in one radio interview. But the reality is that it is going to be impossible to look at the outcome of this process without serious questions. But this is now extremely important when it also involves the evidence leader, Chair. The terms of reference are clear about the role of evidence leader. It must be someone whose task is to assist both the committee and the PP to lead evidence, not in a biased manner. We have studied the submission by Godrich Gardi attorneys and the responses by Advocate Bauer. And our view is that whether the affidavit is this or that, as Advocate Bauer was saying earlier on, it does represent allegations and question the conduct that as the committee, we should not be subjected to the task of judging if it is material enough or not. For example, Chair, in some instance, it is not clear if Advocate Bauer is saying she did some of the things that are alleged for her to have done them, or she did not. She's not clear. Or some of the things are done, she thinks are acceptable, even though they are questionable. It is not clear what she was saying. Now, at some point, it sounded like Advocate Bauer herself wanted to complain about the complainant, because instead of addressing the allegation, she began to discredit the complainant. She went at length to try to discredit the complainant and not focusing on the allegations that are brought before her. All we need to do is to think and prioritize the integrity of this inquiry. Advocate Bauer must recuse herself, not because we are saying she's guilty of the allegations, but simply to allow the committee to arrive at a conclusion on time without challenges that could have been all avoided. That is what we are requesting, Chair. She must recuse herself. Simple suspect of wrong conduct and questions on her involvement will lead us to wasting taxpayers' money. Some will take us to court and possibly we will be forced to repeat this exercise when it could have all been avoided. It should not be a matter of Advocate Bauer must remain as part of this inquiry at all costs. Even ourselves as the EFF Chair, we have raised the matter with the Speaker of the conduct of the legal team assisting the committee. For example, we witnessed here, all of us, a very disturbing scene here when Advocate Bauer passed a note to another committee member which we believe was the name of our Deputy President, Commissar Floyd Shivambu. And soon after that note, Chair, the name of our Deputy President, Floyd Shivambu, suddenly popped up with insinuations of even criminal charges. Now, we are suspicious that that note that Advocate Bauer passed contained the name of our Deputy President. Chair, we are suspicious of Advocate Bauer's political motives, and we are saying for the sake of the committee and the time and the people of South Africa, since we cannot have another inquiry on Advocate Bauer, as that is the work of your own professional body and not us, she must recuse herself and allow us to continue with someone who no one is asking any questions about their characters. I know that, Chair, in the Zondo Commission, evidence leaders were paid close to 50,000 a day. So I'm not sure if it's got financial implications for her to want to remain here at all costs. But we are saying for the sake of the people of South Africa, for the sake of Parliament, for the sake of this inquiry, recuse yourself, ma'am. Let's have a clean inquiry that no one will question the character of anyone who's participating in this inquiry. I so move, Chair. Thank you very much.
Thank you, Honorable Mautwe, for your contribution. I now recognize Honorable Siwela. Honorable Violet Siwela. You are muted, Honorable Siwele.
Thank you, Chairman. Thanks. Chair, by Advocate Bauer. Chairperson, I don't want to waste time. Really, this is quite disturbing because we started this process. Can you hear?
Yes, you're cutting, but please continue. Honorable Siwele? I think she's frozen.
She's off the blood. Oh yeah, she's frozen. Sorry.
Okay, we might have to come back to her. Just mute her in the meantime, as I recognize Honorable Nodada.
Chairperson, can I come back?
Yes.
Chair?
Yes.
I was kicked out.
Just
I'll
hold
try
that.
to be brief, Chair.
Go ahead. Go ahead, Honorable Siwele.
Chairperson, what I wanted to say is that I'm worried about the way we are moving with this inquiry, because, Chair, we started very, very well. We allowed Advocate Bauer to lead us with other advocates. You were also doing your part very, very well, but all of a sudden, there are now a festival of letters which are coming forth here. I'm worried about the cost, I'm worried about the time, and I'm worried about even the integrity of this committee. My proposal, Chair, is that let us stick to the guidelines. Let us proceed in doing our work properly. I don't think that is quite reasonable to can say that Advocate Bauer should rescue herself. The recusal of Mrs. Bauer or Advocate Bauer will really indicate that we are not realistic, because even if we can give marks to all those senior counsel into this inquiry, I think she's one of the best who can top up because of her character, her soberness in doing her job. But today to come and say here she must move out because she's biased, blah blah blah. I'm really appealing to the members of this committee that let us protect this country by doing the right thing. We are not here to politicize. The end of the day, we're going to be told that we're using numbers. There is no issue of numbers here. We need to be realistic, and we mustn't punish a person without evidence. Advocate Bao, according to me, she's doing her work very, very well. Hence, I support her. I'm rejecting the application that she must be taken out because there is no one who can perform better than she's doing. That's my submission, Chairman. Thank you.
Thank you, Honorable Siwele. Honorable Nodada.
Thank you so much, Chair. Chair, before I continue, can I ask if I'm audible?
Yes, you are.
Thank you so much. Chairperson, the first thing I want to state, I mean, it's a few factual points, first and foremost. Here we are members of parliament. And by virtue of being members of parliament, we are legislators, meaning that we are people that make the law. We are bound by the constitution that, by the way, was adopted by the very same parliament that we are in today. We are not a court of law. We are not people that are supposed to sit and determine allegations of criminality or any other form of law breaking for that matter. We are an institution that needs to play an oversight role in those particular entities. Now here we're sitting and discussing issues of allegations on matters that have no relevance whatsoever to this committee, number one. Number two, having no jurisdiction whatsoever as this committee to determine whether the allegations that have been put forward are actually valid or not. So those are the facts first and foremost on the table. So I feel as if, Chair, first and foremost, this is a waste of our time where we are dealing with applications that are put on the doorstep of this committee that actually don't belong here. And now this has required us to engage on matters, by the way, we have no jurisdiction to engage with. And there are some legislators that sit in this meeting that want to make a determination as if they are a court of law or they are legal practitioners that are supposed to process the matters that have been put forward. I've read through the whole response of Advocate Bauer based on allegations that have been made that the UDM and other applicants that have sent to this committee that rely simply on rumors, allegations that have nothing to do with this committee. And it's quite disrespectful to have honorable members and people that are sending things to this committee that actually have no bearing whatsoever. Now, Honorable Maneli raises something very important, Chairperson. And that's that when these issues, despite who is interested in the matter that we're dealing with as a committee, are brought to our attention, we must be very careful of entertaining things that we have no jurisdiction of, one. Number two, ensure that the things that are put on our table, actually we've got a legal obligation to deal with them. And they must pass the test of either our legal services to advise what the committee should be actually dealing with something like this. Now we're spending the whole morning talking about things, by the way, that are no relevant to this committee. Number two, wasting our time, honestly speaking. And thirdly, based on allegations and rumors that we have no business in dealing with. If somebody's got an issue with any person in this country, they've got the courts to go to. They've got the legal route to do that. And once those courts have made a determination as to what the outcome of those allegations are, if they are relevant to this committee, we can then deal with that. But to sit here and deal with rumors is actually really annoying. And members need to understand their role as legislators, and members need to understand the importance of this committee and the process that we need to follow is bound by the Constitution and the laws that we make in this House. So my proposal, Chairperson, is that we must accept the fact that Advocate Bauer has utilized her rights, legally so, not to recuse herself for whatever reasons that have been put on the table on matters that are not relevant to this committee. And I don't even want to go to the merits or the demerits of what she has responded to and what has been put to this committee. And we then make a resolution at this committee is that in moving forward in the future, whatever is put in this committee, one, must pass the test of relevance. Number two, we must be legally guided on whether it is relevant for us to deal with those issues so that we don't sit here and deal with allegations and rumors and people's emotions throwing tantrums around. Thank you so much, Chair.
Thank you, Honorable Nodada, for your contribution. Appreciated. Honorable Busisiwe Mkhwebane.
No, thanks, Chairperson. Firstly, I agree and second Honorable Ngola and all other members on this issue. The matters raised really are not relevant, and they are before other courts or tribunals who can take decisions on them. And therefore, second, the motion by Honorable Ngola, supported by the rest of members. I just want to, Chair, latch on the issue raised by Honorable Maneli, whether ourselves as a committee don't have recourse really, or the National Assembly don't have recourse. I think I would request that, Chair, from where you are, you consider the following. One, request the Speaker through the relevant committee of the National Assembly to inquire from the Office of the Public Protector South Africa whether they've got a budget for legal fees. One. And two, how much of this budget is ring-fenced for Section 194 processes involving the PP? In the following financial years, 2021, 2022, 2022, 2023, and 2023, 2024. So that the Public Protector South Africa really tells us that can they stretch, can they afford to spend taxpayers' money on a strategy really that is meant to stall the process. Secondly, Chair, I want to also ask you to consider asking the Speaker and Parliamentary Legal Services to do the following. Whether the National Assembly may not approach the Constitutional Court to ask for a declarator or a decision that compels the PP to utilize and exhaust processes of this committees, the Section 194 committee, before approaching any courts. Because I think that this approach of being in the committee and at the same time on the steps of the Western Cape High Court is very problematic. And we can't proceed as if we cannot ourselves as the National Assembly and as a committee approach the courts to compel participation by the Public Protector. And that also in that, consider to ask the Public Protector to avail herself of the extensive audit processes that have been provided here by this committee and exhaust this internally before she considers going to other tribunals before matters are resolved in this Section 194 committee. And this would be done, Chair, without limiting her rights. Thank you, Chairperson.
Yeah, thank you, Honorable Busisiwe Mkhwebane. All the contributions and the proposals are noted that you have made. I now recognize Honorable Kijimanis Kosana.
No, thank you very much, Chair, and greetings to all members and everyone present. Yeah, Chair, I would like to join other members in noting both the recusal applications that have been made by Honorable Holomisa and the Gadi attorneys, and also note the response thereof by Advocate Bauer, SC. Chairperson, my understanding that recusal applications in inquiries like ours should be made if there's a real or reasonably perceived conflict of interest, or if there is a reasonable suspicion of bias based upon objective facts. So, Honorable Chair, to the extent that the grounds captured on the two recusal applications are not directly related to this inquiry. However, they are based on matters that fall outside the scope of this inquiry. So on the basis of that, I agree with members that says that we should not accept these recusal applications, and also support the decision taken by Advocate Bauer not to recuse herself. Honorable Chair, it has been stated time and again, and I think Honorable Nodata captured that point, that we are not a court of law. We are not a court of law. So we don't have mechanisms, or we don't have a mechanism to deal with other matters like a court of law. Ours is only limited to the scope of our work, which is an inquiry into the fitness of the public protector to continue holding office. So if there's a recusal application, it should be related to our scope of work. I think in a month ago, we were dealing with a recusal application that was submitted by the public protector, where they were asking yourself and Honorable Mailham to recuse yourself from this inquiry. And in my view, that application was relevant because that application was dealing exactly with the work of the committee. They are saying you are perceived to be biased in the manner that you are sharing meetings, the decisions that you are taking and so forth. They say Honorable Mailham is conflicted because of being married to Honorable Mazzoni and so forth. So I think that was a relevant application. But these other two applications that we are dealing with today, they are not relevant because they are dealing with other matters. They're dealing with matters that are outside the scope of this committee. No matter how serious those matters are, but the fact of the matter, they fall outside the scope of this committee. And that's this committee. We are not a court of law, and therefore we don't have a mechanism to deal with them. So there's no way that we can make a pronouncement whatsoever in relation to those particular matters, no matter how serious are they. Whether they are true or not is another matter, because I don't even want to go to the contents of the contents of the applications or the contents of the response by Advocate Bauer, because the fact of the matter, these matters are not related with the committee. In this committee, in this inquiry, Honorable Chair, we have had witnesses who appeared before the committee, who self-confessed that they have been convicted in a court of law for one case or another, and others they've got pending cases in a court of law. But we couldn't say to them, we can't listen to their evidence on the basis of the fact that they've got pending cases in a court of law, or they've been found guilty in one or two cases. But we allow them to present evidence because our interest is only limited to the evidence that relates to our work as a committee. Anything else which is not related to our work, we are not interested in. Whether a person's character is questionable or not, it's not for us to make a determination, because our interest was on the work of the committee. So even those witnesses were allowed to make presentations in this particular committee because we were only interested on their evidence that relates to the committee. So if we are to deal with characters, it's going to be a very difficult matter to do. And I don't think we do have a mechanism as a committee to deal with that, to look at character of people and stuff like that, because we are not a court of law. So, Chair, I think I'm agreeing with members who say in future we need to look at applications that comes to us on the basis of relevance, whether is the application relevance, does it deal with matters that are before the committee before we can handle it. If an application, I think, is irrelevant, I think we don't have to entertain it. We just have to respond to the author of the application to say, but this application, as much as we're raising important issues, important allegations, but it's not relevant for our work. Maybe other structures or other organs of state or law enforcement agencies or court of law, whatever, they can deal with such things. But Tina, I think our scope is limited, so we won't be able to look at everything that members or other parties might want to place before this particular committee. So thank you very much, Chair.
Thank you, Honorable Gijimanis Kosana. On that note, that would have been the last end from the members. Perhaps just three areas to attend to. I'm going to ask Ms. Fatima Ibrahim to make brief remarks before I summarize and wrap up. But before that, if Advocate Bauer on very limited clarity is able to respond to some of the clarity sought, I'm going to ask her to do that. Advocate Bauer.
Sorry, Chair, maybe Ms. Ibrahim should go first because it might very well just cover everything that's been raised.
No problem. Ms. Fatima Ibrahim.
Good afternoon. Thank you, Chair, and good afternoon to the members and everybody else on the platform. Chair, I'm not going to deal with the merits of the allegations or the circumstances of the litigation matter. I think Advocate Bauer has covered that extensively, and that in any case, it's not my role to do so. But I will make some brief remarks in respect of what I think that the committee should consider or take heed of. Firstly, Chair, the rules of the Assembly never provided for the appointment of an evidence leader. Members will recall that following the Constitutional Court judgment that confirmed the Western Cape High Court's ruling that the PP must be afforded legal representation and a legal representative who would be allowed to participate in the proceedings of the committee. This committee then decided that it would be necessary for us to have an evidence leader. That was included in the terms of reference, and the terms of reference it dealt with the appointment, but it did not deal with the removal of the evidence leader. That being said, as the appointing body, this committee, of course, has the power to make a decision to so remove the evidence leader. So there would be nothing untoward or unlawful in making such a decision to remove the evidence leader. Chair, I secondly want to just comment on the nature of these so-called recusal applications or recusal requests. And I say so-called, Chair, because the legal concept of recusal relates to allegations of bias or conflict of interest. And such allegations are not being made here. Certainly, I cannot see that in the submissions that have been made. They seem to relate entirely to a litigation matter in which Advocate Bauer has found herself acting for one of the parties. And while she has made the links between that litigation matter and the current process before the committee, it does not in fact have any bearing on the work of this committee. There is no reason in law that I can see from anything of what's been submitted that would prevent Advocate Bauer from continuing as an evidence leader. The allegations made against her remain allegations, and there's no finding against her of having breached any laws, nor has she been convicted of any crime or found to have breached any ethical standards in terms of the professional standards that she's held by. It's also unclear as to how her continued participation in the process could pose any legal risks. And I say this because there has been no case made out for biasness or conflict of interest, which would have been the legal test that we would have applied. So what it seems to me to be is that what the requests, in fact, are removal requests based on the fear that her participation in the process, because of these allegations, might taint the process. So it's reputational in nature rather than legal. But from my understanding of what members have said so far, it seems that members have adequately grasped that. The role of the evidence leader has been clear from the beginning. As per the terms of reference, the evidence leader is not a prosecutor. The evidence leader is not a decision maker in this process. The role is purely to assist the committee by placing the evidence before the committee, but it's the committee itself ultimately that would need to weigh that evidence and determine what its recommendations will be to the assembly. Chair, I'm not going to go through some of the other things that I've prepared because I think members have covered it. But it seems to me that the question, in fact, is whether members are of the view that based on these allegations, they have lost, there's a breakdown in the trust relationship with Advocate Bauer, and they feel that therefore she should be removed, that she would taint the process. And it's appearing to me from what I'm hearing that the majority of members don't feel that way. Nonetheless, members must take cognizance of what the allegations are. I think that they have. I've noted the proposal that we allow the complainants and then Mr. Kulu, whose affidavit forms the basis of the two complaints, an opportunity to come before the committee. Chair, I respectfully disagree. That litigation process has nothing to do with the work of this committee. The affidavit and what is contained there in those allegations must be tested by a court, and they will be tested by a court. It's got nothing to do with this committee at all. The mandate of this committee, in fact, is very narrow. Now, I note that the allegation against Mr. Kulu is that the monies that he's alleged to have taken relates to public funds. It may well be that the PC on environmental affairs would want to consider getting an update on this matter because it does involve public funds, but it certainly has nothing to do with the mandate of this particular committee. So we cannot allow an inquiry within an inquiry. Chair, I want to remind the committee of its constitutional obligation that this matter must be dealt with diligently and without delay. There have been various delays since the start of proceedings. And it is important that we keep focus and that we don't lose track on what we mean to be doing. That being said, Chair, should the committee wish to remove Advocate Bauer because they feel that they've lost trust in her, then they certainly can do so. But in so doing, it won't be based on any legal grounds, as far as I'm concerned. It would be a reputational issue and nothing more. Chair, those are my brief remarks. I don't know if there was anything else that I didn't cover. Or if Advocate Bauer wants to add anything on her side. Thank you, Chair.
Thank you, Ms. Ibrahim. Before I proceed, Advocate Bauer, if there's anything you want to reflect on?
Yeah, I'm going to limit it to issues of clarification and not engage in a dialogue with anything that the members raised. There was a question raised as to how we made the link between the invoice that I indicated was before the committee and the reference to payments that have been made in the pending in the matter. There was correspondence that was tabled before the committee by the Secretariat. A copy of that invoice is indeed attached to it. This is evidence that we plan to leave through Mr. van der Merwe, but because of interlocutory applications, that evidence has now been delayed. But the invoice can be seen, and I know there's many attachments, so it may well be missed, but that invoice is indeed already provided to the committee. The second issue is this inquiry is being limited to the questions, or this committee's discussion today is being limited to the questions that have been raised in the communications put before the committee, to the extent that there's now been reference made to a particular note, which everybody saw was being passed in an open hearing. That note lies with the Secretariat. The contents of it would be quite clear. Within minutes of that, I had a good chuckle with Advocate Mpofu about every kind of nefarious motive that's going to be attributed to it. And the BB's legal team was invited by myself to go and have a look at how innocuous it was. I'm going to ask the Secretariat to make it available to all members so that that could be put to bed without any guesswork about what was actually contained on the note. I don't think there's any other issues that arose that particular clarification needs to be raised by me.
Thank you, Advocate Bauer. Colleagues, honorable members, and everybody, thank you very much for your contributions and interventions here. Perhaps by way of summary, colleagues, I think the first point to make would be to appreciate and perhaps ask all of us to appreciate that. I think the key issue you are raising is that we must stay focused on our mandate, keep our eyes on the ball. I think that point is taken firmly. But I want to say, as we do that, as we stay within our mandate and stay focused, I do want to urge members that and this is how I want to put it, that as we stay focused and staying put into our mandate, we must have what I call listening ears, and we must have seeing eyes. In other words, on scanning clap is drani. We can't have that. We must be able to, whilst staying focused, also be seen that we are a listening committee. We do see things, and we attend to those things as we march forward with our task of executing this mandate, which is about the fitness to hold office of the Public Protector. I think we do have that ability to attend to that complexity of issues and navigate those issues. So nobody must feel that doors are closed, ears are closed, eyes are closed. We just don't want to hear anything else. We must have those listening ears and seeing eyes as we approach our task of testing this fitness to hold office. I want to emphasize that point. I think members are making a strong point that we must, especially from myself as the chair and the supporting team, our legal services and so on, that the next kind of request and correspondences must pass the test of relevance, so that we don't bore you with issues that we should have assessed, whether they should come to the committee or not, or in what way they should be attended. We take that task, that we're going to have to do that work as you request us to do. Certainly, Honorable Mautwe, your point is taken. You've made a firm view about the need for us to protect the reputation of this committee and its integrity. And in your view, you thought that including when the chair, Mr. Milam, and now the evidence leader, it would have been better if we, in the interest of a reputational picture, that she recuses herself. That point is noted. However, having listened to everybody in this meeting, it is clear that out of those 14 members who would have spoken here, that about 12 of them are of the view that we do need. It's clear that firstly, the point being brought to this for recusal bears no relevance in relation to the work of this committee as a starting point, before you even get into the contents of what is being raised. That if you play cricket, there's something in cricket called leg before wicket. So if that happens, it doesn't matter what happened thereafter, whether this would have hit the ball or somebody would catch it. There's a starting point of relevance and a minimum requirement that you need to meet. And members are very clear that this application has nothing to do with the work of this committee. And therefore, as far as their concern, should not have been entertained. And as such, they support the decision of the evidence leader not to recuse herself and firmly reject, therefore, the application. And that would have been moved and supported by quite a number of members in that regard. I have taken note, Honorable Busisiwe Mkhwebane, and between myself and the legal services, that's a matter we're going to have to pursue, of the kind of proposals you have placed here, beyond the matter that we're dealing with, as a way of protecting the constitutional work of us as legislators and the work of this committee. The points you've made in relation to what the certain things that we need to pursue and request, whether it is with the Justice Committee, which will be meeting today to consider coincidentally an annual report of the Public Protector South Africa, the issues that you are raising there in relation to that committee that plays oversight role. You've raised issues that we need to be occupied with and see how far we go with those in relation to the issue of ensuring that all the audit processes are exhausted in protection of the public protector for her to be afforded the opportunity, but also to ensure that her participation becomes sustainable in this process. And you'd have made points about further work that we might need to do in relation to other platforms and forums that would assist us in relation to that through the Speaker's office and so on. All of those points have been noted, perhaps as a homework that we're going to check how doable those things are. And therefore, in that regard, colleagues, in relation to what is in front of us, the decision of this committee is that we accept Advocate Bauer's decision not to recuse herself. We note the points raised about, the concerns raised about issues of reputation and the need to protect the committee as raised by other members. But the decision of this committee is that we proceed. We now need to proceed with our work. And you would have seen, you would have received actually today's agenda. You have also received an agenda for Thursday and Friday next week to indicate and that we are to demonstrate that we are ready to proceed with the inquiry, to conclude the outstanding witnesses, and therefore begin to look into the next steps of this process. I think that I want to say up front, we're not just going to be concluding on it. It is already planned in process. We would have communicated in that regard through correspondence with the public protector for their readiness around those kind of issues. With that, colleagues, I want to summarize that matter in that way before I ask Temi Nkosi to take us through the correspondence quickly. But I see a hand raised there. Honorable Mautwe.
No, thank you very much, Chair, for recognizing my hand. Chair, just a quick one for me. I just want to put on record that this is not a majoritarian exercise. It must be noted like that. The importance and strength of democracy is the ability to hear the minority views when there is a slightest sense of truthfulness. So it doesn't matter whether 12 members said whatever they said and 2 members are saying something different. We still stand by our submission. Chair, can the objection of the EFF of your decision be noted by that the EFF rejects that? And can it also be please recorded in the committee report as such? I thank you.
No, thank you, Honorable Maute. In my summary, I would have noted and appreciated the point you've made. You've placed firmly of not supporting acceptance of this non-recusal. That's been noted, so there's no problem in us doing that. And the point here, it is not just about numbers. Each of the members that spoke when we're given an opportunity dealt in their own contributions with the detail and the contents of this response. They did not just raise hand and then said count us and so on. So they dealt with the content of what is placed in front of us. So it would not be correct if there is such a perception that it was just a numbers game. It's an overwhelming view which is backed by clear articulations and argument in line with what is in front of us. I thought it's important, but your points are noted and registered as such. I would have raised myself in that way. Thank you, Honorable Maute. Colleagues, we proceed, we step off from this item. I want to invite, you are excused, Advocate Bauer, at this point in our meeting, as I invite Mr. Ngoma to take us to the last item.
Thank you, Chairperson. Good afternoon, and good afternoon, honorable members. Chairperson, as you have already indicated, that my role in this meeting for now is to table the correspondence before the committee. On the screen, I have on the 18th of October, which is the Tuesday, received a letter from Sianeho attorneys regarding the recusal application of the chairperson and Mr. Milem, and requesting reasons for the recusal, for the refusal to recuse themselves and the documentation thereof, which is when we responded on the 18th and provided that information to Sianeho, and also received another letter on the same day from Sianeho. The letter was talking on the notice of application for adjournment. Firstly, they were requesting appropriate time to study the documents that were provided to them, indicating that 72 hours would not be enough, as members would be aware that the plan was to have the inquiry proceeding today. And also indicating that they have a matter before the Western Cape High Court on Tuesday next week. And also, as I've earlier indicated, submitting a notice to file an application for adjournment of the committee. Those letters I have shared with members, and I think the committee will deliberate more, in particular the letter with that notice. And then, Chairperson, lastly, the letter on the 19th of October, which was then responding to Sianeho, just indicating that, acknowledging the receipt of their communication, which had indicated the notice of application of adjournment, and also indicating that the committee will then discuss the matter. But we had members, as would have seen, that we had made preparations, we proactively requested next week, Thursday, if this committee agrees to deal with that matter. Chairperson, for now, I'd like to thank you very much.
Thank you, Mr. Tembeko Ngoma. Just to conclude this correspondent part, I wanted to add, as I indicated at the beginning, that on the 5th of August, we would have received the correspondence from the chief whip of the EFF, laying a complaint about the evidence leaders in relation to matters whether they would have made additions to Mr. Samuel's affidavit, and matters that were not brought to the attention of the PP team. I did ask the evidence leaders to respond to that, which they have. And therefore, having received that, I will be forwarding a response correspondence to the EFF immediately after this to indicate the outcome of that. I just thought I must just add, because that letter would have been tabled on Monday when we dealt with this. So thank you very much, colleagues. That's the correspondence that we have today. If there's no other matter, question, or response to that, or clarity, it will signal the end of our session today, so that we begin to start joining to be ready for the 2:00 house sitting. Thank you, colleagues. I see no hand, therefore, in that regard. Thank you very much for your participation and for your contribution in directing the work of this committee. It's a novel process. You're navigating a lot of issues that are complex. I really appreciate that I'm able to work with this team that is so diverse in their thinking and their intervention. Thank you very much, colleagues. The meeting is adjourned.
Thank you, Chair. Long live the Chair. You can smile.
The Portfolio Committee on Human Settlements has initiated a public participation process on the Housing Consumer Protection Bill. The purpose of the bill is to provide for the protection of housing consumers, to provide for the continuance of the National Home Builders Registration Council as the National Home Building Regulatory Council, to provide for the registration of home builders, to provide for the enrollment of homes in order to be covered by the Home Warranty Fund, to provide for the regulation of the conduct of home builders, to provide for the continuance of the Home Warranty Fund, to provide for claims against the fund, to provide for the funds of the council and the management of these funds, to provide for procurement and contractual matters in relation to the building of a home, to provide for the enforcement of this act, to repeal the Housing Consumer Protection Measures Act of 1998, and to provide for matters connected therewith. The Portfolio Committee on Human Settlements will be conducting public hearings in Northwest from 21 to 23 October in the following areas: in Klerksdorp on Friday 21 October, Mahikeng on Saturday 22 October, and Rustenburg on Sunday 23 October. Watch the public hearing on the Housing Consumer Protection Bill in Rustenburg on Sunday 23 October, live across Parliament's platforms from 10 a.m. to 2 p.m. All public hearings are live streamed on Parliament's social media platforms. For more information, visit Parliament's website on www.parliament.gov.za. Parliament, following up on our commitments to the people, making your future work better. The Portfolio Committee on Environment, Forestry and Fisheries has initiated a public participation process on the National Veld and Forest Fire Amendment Bill. The objectives of the National Veld and Forest Fire Amendment Bill are to amend the National Veld and Forest Fire Act of 1998 so as to amend and insert certain definitions, to provide for the facilitation of the formation of fire protection associations by a municipality or a traditional council, to compel a municipality, state-owned enterprise, public entity, or other organ of state which owns land to join the fire protection associations, to extend the powers of entry, search and seizure, and arrest to peace officers and traditional leaders, to amend the title of the Act to the National Veld Fire Act, and to provide for matters connected therewith. The Portfolio Committee on Environment, Forest and Fisheries will be conducting public hearings in the Western Cape from 21 to 23 October in the following venues: Klapmuts Multipurpose Center on Friday 21 October, Houston Tusong Center in Hermanus on Saturday, 22 October. George